Last time, we reviewed the Virginia and Maryland Railroad Company versus White case from Virginia, 1984, where we found a split amongst all the justices, where upon examining the sole question on that appeal, whether White was guilty of contributory negligence as a matter of law in his own death, crashing into a railroad car, we found that the majority affirmed and concluded that reasonable minds could differ respecting whether Mr. White had been keeping a proper lookout during those few seconds while he drove up to that fatal crash. They held that the trial court below them did their job effectively, correctly. However, two of the few justices dissented, arguing essentially that the relative degrees of culpability regarding the amount of negligence that one party brings into a situation and another party, that they are independent, and as a result of that holding, further evaluated that, in essence, they felt that Mr. White simply did fail to see what was there to be seen. Having it ultimately be the case that, in the dissent's opinion, a reasonably prudent driver in that decedent's position and under those attendant circumstances would have reasonably, for sure, just about, slowed down and thus avoided that collision that killed him. About this, the dissent does not believe reasonable men could differ, and therefore they would have voted to reverse the judgment of that trial court below and rule that Mr. White had been contributorily negligent and thus contributed to his own death, thus relieving the railroad company of some portion of liability. We asked last time, who was correct? First, to cover a couple of points that we had passed by earlier last time. In a quick review once again from the top, we'll first quickly cover a few important points. Let's remember that as a rule, because that plaintiff prevailed in the court below, in the trial court, the appellate court, by its own rules, is bound, and by case precedent, case law as well, I figure, to state that evidence from that case below, and all reasonable inferences that are deduced therefrom, in the light most favorable to him. This is very important. Let's also recall that on the morning, apparently, or rather, as it says, at the time of the accident and for approximately 36 hours prior thereto, the warning device that was normally operational was not operational. Further states that the company, the railroad company, had tied up those gates with ropes while repairing the tracks. We'll bring to mind that the presumption, of course, is that at least on that particular day, while Mr. White was going to work earlier that morning, he is presumed to have noticed and seen that those railroad tracks at that time, or at least on that morning earlier, had been non-operational because those ropes were there. This leads us to bring to mind, were those same ropes still up later that day? Moreover, if you're driving in the morning and you see the railroad tracks, that there's some kind of construction project going on and that there's something unusual, that there are ropes there, does that necessarily reasonably lead one to cause to bring to mind that there still may be an issue later that night if you were to drive back? We'll hold that question to mind while we continue examining. We also remember covering the fact that if a lantern is to be used for flagging, it is a red bulb that should replace the white bulb. However, even using that is not standard protocol, and that normally fusees are used to draw the attention of passersby. Let us next bring up to mind the standard regarding matters of law and matters of fact. Issues become one of law to be decided by a court only when reasonable minds for sure could not differ concerning the conclusion to be drawn from the evidence. Important, and this is the standard by which we will examine the facts. we must show that it is strictly and plainly unreasonable for the lower court to have held that White was necessarily free of contributory negligence. Unreasonable. That's the standard by which the ruling can be reversed, and nothing short of that. So, in order for the position of the railroad company to succeed on this appeal, in order to obtain the kind of decision that the dissent in this case advocates for, it must be found that it was necessarily unreasonable to have found that Mr. White didn't somehow fail to keep his vehicle under proper control, and that it is unreasonable for the jury to have found that he didn't fail to keep that proper lookout. So, let's take a look at the merits of the dissent. I gotta tell you, it's an interesting case. It's a close case. At first glance, when one finishes reading the opinion of the majority, and then they take a look at what the dissent writes, one is almost brought to side with this dissent. Just like this. And finding, sure, yeah, the guy should have seen it. And because he didn't, we have the issue here. And yeah, it looks like the trial court may have erred in their decision below. And that judgment or finding should have been reversed. There should be some negligence attributed to Mr. White himself. However, who's ultimately right? Here's why. Important to note is that a driver in Mr. White's position had split seconds to make quick decisions that would have, in this case, did ultimately impact his life. We can draw the parallel to findings such as that in a case, Graham versus Connor, 1989, from the U.S. Supreme Court. The court here finds that when evaluating a police officer to determine whether his actions are reasonable under the circumstances, they note that the proper application of a test of reasonability requires careful attention to the facts and circumstances of each particular case. As far as police officers go, this includes the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether the suspect is actively resisting arrest or attempting to evade arrest by flight. Ultimately, they find that the reasonableness, in this case, of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight. This is known as the objective reasonability test. As applied to police officers, for example, they continue on with respect to a claim of excessive force. For example, the same standard of reasonableness at the moment would apply. Not every shove or push, even if it may later seem unnecessary in the peace of a judge's chambers, would be subject to such scrutiny as to invalidate it on a basis of law. The reason being that some practical allowance must be made and thus we begin to see, returning here to the railroad company case, that what the dissent does do is apply a 20/20 hindsight analysis onto what the driver should have seen and should not have seen and could not have seen. But the practical problem is that in a split-second decision-making situation of that nature, would reasonable men necessarily have avoided the same fate. There are reasonable holdings and there are reasonable actions. A reasonable holding is a holding that essentially would not be held any differently by the hall of reasonable minds that would assess the situation. And reasonable actions are those actions that reasonable person would have adhered to or would have prevented from avoided doing, such that anybody else in the same position, applying the same standard of ordinary prudence and care, would necessarily have also done the same thing, avoided the same problem, and obtained the same safe and careful result. When you have reasonable cause to hold a thing as true, you're essentially admitting that any alternative hypothesis, situation, or outcome with respect to what this truth actually may be, is, in essence, a remote possibility. Alternately, it is to admit that the possibility or proportion of likelihood of the alternative thing occurring is essentially negligible. Therefore, we are here to evaluate whether any driver exactly in Mr. White's legal position and actual position, we're here to evaluate whether the chance of that same thing happening to any other person or driver in his position with the exact same circumstances in effect on that day, whether the proportion of them ending up in any kind of injury state or problem is merely negligible. And if the chance of an accident is a remote possibility at best, here's what the dissent fails to see. On the one hand, they are correct in their holding that the negligence of a plaintiff and the negligence of a defendant are independent factors, or at least more correctly, that they can be. However, even though they're technically correct, that generally the increase of the negligence of one party does not necessarily imply causation of the decrease of the contributory negligence of the other party, what they fail to ultimately realize is that nevertheless, in this particular case, it does. Why is this? Because if the railroad company had been using red bulbs or fusees, the actual probabilistic proportion of drivers in exactly the position Mr. White was in, having 3 or so seconds to react to something before you're dead or injured, that proportion would realistically have been brought down. For a driver beholding a red light or other plain visual cue that the railroad company was responsible for ensuring at that point in place in time, it would have had the reasonable driver notice the signs sooner. The ultimate question to ask at this point is simply this. If I magically took 100 random individuals back in 1984 and put them in that driver's seat exactly where Mr. White was sitting, we put 0.10, 0.11 blood alcohol concentration in their blood instantaneously, and then we play the scene over and over again as if to reverse the reel, go to exactly that first moment where the ideally, in the most ideal situation, you would have noticed that there's a problem back when the traffic light turned green in that 3 or 4 seconds of distance between driving up to the railroad tracks. And we put person number 1 in there, and then we play the reel. We say, boom, go. and he's running forwards. Okay, here's the game, as if you're on a living game show. You're there. You have 3 seconds to see the signs, or you die, or get injured. Boom. Railroad car's dark. I don't see any lights. I don't hear any alarm sounds. I see some light. I don't know what that light is. It's not red. It's white. Okay. Who knows what that is? Who knows why he's doing that? Oh, there's 3 cars stopped here. Why are they stopped? I'm going to go, oh, that's why they're stopped. Oh, too late. Okay. Take human being number 2. Put them in the same situation. Replay. How would human being number 2 have done it? Oh, driving. Oh. That's the is that the let me slow down for a second. Okay, slow down. Good. Save his life. Human being number 3. Go. Oh, splat. Now, do this 100 times over. Okay. Now, if the proportion of the is a potentially infinite amount of human beings that you can place into there and then replay the situation over and over again, if the proportion of people that would have ended up failing to see the signs before it was too late, if that proportion is greater than negligible, if out of 100 people, maybe 96, 97, 98 of them stop in time, but like 1 out of 50, circumstantially 1 out of 50 odds probabilistically that you don't stop in time, you slam on the brakes and you're screwed. 49 out of 50 being safe, 1 out of 50 not being safe is not reasonable cause or reasonable standard. That is an absolutely excessive danger. There is no contributory negligence. The chance of a person who is exercising ordinary care in that situation nevertheless ending up injured, it's simply, honestly and practically speaking, greater than a remote possibility. The likelihood of an injury taking place is greater than negligible. Therefore, it is not reasonable to hold that drivers in that position across the board would necessarily have consistently avoided a problem in the ordinary course of their driving, because we can't tell necessarily that they would have. That's why the dissent is wrong. They say he was contributorily negligent because he failed to see what was there to be seen. That is not the standard by which negligence is determined. They say he should have seen it. In the theory, you should have. But without 20/20 hindsight, the same standard of reasonability used for a police officer, that is the standard that practically ought to and should righteously and justly apply to situations where there's second-by-second real-life tense situations of not being sure. Well, in real life, you're not sure. I left a kid on a school bus. Am I a criminal? This is what a woman named Victoria Affia may have been asking herself and other people around her back in 2007. She was arrested, charged, and found guilty, inevitably, of the attempt, that is the criminal attempt, of endangering the welfare of a child, and to find Miss Affia guilty of this without direct proof that the defendant intended to endanger the child. This case, like the previous case, was brought up for appeal. Miss Affia didn't feel that the conviction was just. Let's read the circumstances. This is the opinion of that appellate court, the appellate division, who's reviewing the case that came up on appeal from the trial court level. Imagine being in this woman's position. We'll find out what happened. We're going to analyze carefully also and examine to find whether this appellate court's decision was correct. Now, the previous case, very sad case, resulted in somebody's death. It's the most serious kind of civil case that you can have. But was also just as serious, almost, is on the criminal side. When someone is found guilty of crime, their rights are subsequently taken away. They lose the right to freedom. You have a criminal record for the rest of your life, or at least for a considerable period of time. And yet, we must bring to mind a very important principle in law that, as it has been stated over the decades, if not centuries, it is better for 100 guilty people to go free than for one innocent person to be found wrongfully guilty and to suffer. We proceed to read. The evidence in this case, tried to the court, proved beyond any doubt that the defendant, Miss Affia, who was a school bus attendant, whose sole job was to supervise no more than 12 children, left a kid who was at that time 7 years old, the complainant in this case. She left him asleep on the bus. One morning, presumably, he remained there while the bus was driven halfway across Brooklyn, New York, and parked. The issue in this case is whether these facts are sufficient to convict the defendant of attempted endangering the welfare of a child. That is Penal Law subsection 110, which is attempted crime. We'll examine these things shortly. And 260.10, that is endangering the welfare of a child. They convicted without direct proof that defendant intended to endanger the child. Under the circumstances of this case, we, the appellate division, hold that the facts are sufficient, and therefore we do find the defendant guilty under the statute. Wow. Let's see the details. On February 16th, 2007, Isaiah M., a special needs child who was then 7 years old, was placed on the school minibus by his mother that morning. The minibus had a seating capacity of 12 people, including the defendant, a school bus attendant who was responsible for ensuring the children's safety, including the safety of that child. That's her job. During the trip, poor old Isaiah fell asleep. He did not get off the bus when it arrived at his school, and he instead woke up sometime later, alone in the unfamiliar location where the bus ended up being parked. The people called 6 witnesses in support of their case. First, the people called Doreen Foy and Joseph Van Aken, both instructors with Pupil Transportation Professionals, a training center for school bus drivers and attendants associated with the New York City DOE. Ms. Foy and Mr. Van Aken testified that each bus attendant in the defendant's position is, in fact, trained to sit at the back of the bus behind all of the children. They're trained to note the presence or absence of each child on a trip sheet given to them for that purpose. They're trained to walk to the front and back of the vehicle when the bus arrives at school, checking each seat for sleeping children, and after completing this function, they're trained to place a placard at the back window stating, in essence, this bus has been checked for sleeping children. Ms. Foy testified that she herself had trained that defendant, Victoria Affia, A copy of a certificate labeled School Bus Escort Basic Training Program issued to the defendant in 2004, about 3 years prior, was admitted into evidence to establish that she had been trained. The people next called the complaining witness, Isaiah M., the kid himself, who gave, to note, importantly, this is unsworn testimony on account of his age. Under New York's rule of evidence, statutorily established, we see that every witness more than 9 years old may testify only under oath. And furthermore, that a witness less than 9 years old may not testify under oath, unless the court is satisfied that he or she definitely understands the nature of an oath. Special needs child certainly would not. Also interesting to note, in the next subsection, that a defendant may not be convicted of an offense solely upon unsworn evidence given pursuant to subsection 2. We'll keep that in mind to consider, but for now we proceed. The complaining witness, Isaiah, testified that he woke up where the school bus was parked on the street. He further testified that alone and in an unfamiliar place, he opened the door of the bus. He got off, and he sought the help of the nearest stranger he could probably find, who did find him in the middle of the street, and who did bring him to a police precinct. Now, Officer Joseph Vukovic, the people's next witness, was there to testify as well, that this Good Samaritan had in fact come up to the police station and did bring Isaiah there, to the police station, or the police precinct that was in Bensonhurst, Brooklyn, which the court will take judicial notice is many miles from Isaiah's school and home. It's amazing. It makes you actually think for a minute. It's this woman who's on trial. That's interesting. Maybe it was her job to check. What about that bus driver? He was the one who was actually taking him away from that school. Is there any responsibility of a bus driver to ensure that they're who your passengers are at any given time on a vehicle that you're operating? Very interesting, right? Officer Vukovic additionally testified that the defendant was arrested and brought to the precinct later that day, where she gave a statement. Wow, just like that, they got her later that day. Never mind the bus driver, but this woman, we got her. What a life! I could get a job as a bus driver, drive a sleeping kid in my bus halfway across Brooklyn, and it'll be somebody else that gets charged, not me. Ooh, I love it. Talk about negligence, right? As related to the previous case. But anyway, the people then called Isaiah's mother, Shirley, who testified that on the morning in question, she placed her child on the school minibus, a vehicle with a seating capacity of 12 people, this is very important for some reason, in front of their residence in East Flatbush, to be driven to school in Canarsie, more than a mile away. She identified the defendant as having been Isaiah's bus attendant on that date and for the entire school year. So, let's see. February. Okay, so you're about 4 or 5 months into the school year. You've been doing this for quite a while. You've fallen into the habit of doing the same old thing every day. Did her job successfully every single morning. She did it right 100 and something, 200 times, until the moment and the day that she didn't do it right. By common sense, presumably by accident. Nobody purposely leaves a child on a bus. You definitely can infer that reasonably. And that is very critical to note as well. We'll continue. Later that day, Miss M., the mother, received a call from the school informing her that her child had been left on the school bus, and she retrieved Isaiah from the hospital. Oh, poor kid. In the hospital. Gotta make sure he's not traumatized for life, psychologically. Yeah. where he had been taken for, well, it's a special needs child, so in that case, perhaps it's not totally bonkers, but hey. Retrieved from the hospital, where he'd been taken for examination following the incident. It's a prudent thing to do. It is. Maybe back in my day, I wasn't on a school bus, but, I'm in Brooklyn, New York myself. If you were left on a school bus somewhere, maybe you would have just been brought into school later that day. Oh, he had an interesting day, this kid. Maybe he'll go to see the school psychologist and talk to them for a few minutes and make sure, nothing crazy happened. Today you end up at a hospital. I don't know. The defendant, now, Afia, poor woman, honestly, made a big mistake. I end up in a court. Defendant did not call any witnesses. Maybe there's no need. Enough of the facts have been established, perhaps. But at the conclusion of the trial, defense counsel argued that the people had failed to prove the crime of attempted endangering the welfare of a child beyond a reasonable doubt, because the people failed to show the defendant's knowledge that her conduct was likely to result in child's harm, and that sometimes a mistake is just a mistake. Let's consider the situation here. The first thing that strikes me as interesting or really unusual, almost suspicious, is that the woman wasn't actually charged with endangering the welfare of a child. She was just charged with attempted endangering the welfare of a child, it seems at least. Now, why would the court or the prosecutors do that? First, let's see here. Endangering the welfare of a child. There's 3 subsections to this. Only the first one is important. A person is guilty of endangering the welfare of a child when he or she knowingly acts in a manner that is likely. The definition of likely legally is more likely than not likely. Like a preponderance of the evidence sort of deal, similar. In a manner likely to be injurious to either the physical, mental, or moral welfare of a child less than 17 years old. That's it. So, there it is in its entirety. Let us look at and extract every single possible element to observe and see and behold exactly what this consists of. Guilt is established, reasonably so, when the person acts with knowledge or awareness. And perhaps you may add the question whether it's actual knowledge that needs to be there versus constructive knowledge. A little bit of a side analysis that may apply. There needs to be a true and actual likelihood of injury. Note, it doesn't matter whether injury actually happens. It's about avoiding the thing that has a certain amount, the requisite amount of built-in likelihood or risk of injury built into the situation. If you end up inadvertently injuring a child by some 1 in a million shot, you're not guilty of this. Mind you, if you don't injure a child, but you engage in something that had a real big likelihood of injuring that child, it just happened that he wasn't injured, you still will be guilty of this and you can be charged. It has to be injury to the actual mental welfare of the child. And we can look up definitions and understand what it is for the mental welfare to be affected. What does mental welfare mean? Is that just how you're feeling that day, or true, lasting psychiatric disorder / trauma? And lastly, it's got to be a child. Now, mind you, she wasn't charged with this. She was actually charged with this. A person is guilty of the attempt to commit a crime when with intent to commit a crime. He or she engages in conduct which tends to affect the commission of such crime. Keyword here, intent. So in context, the question here is, did the woman intend to knowingly act in a manner likely injurious to a child? And did she furthermore intend to knowingly act? The defendant says that the prosecutor / the people failed to show that the defendant even knew that her conduct, that she was doing something that was likely to result in the child's harm, let alone that she intended to engage in such a thing. A mistake is just a mistake. Defense counsel further cited People versus Simmons, where in that case we can read carefully here to see what they ruled back in 1995. In that case, we found that the appellate division determined that the defendant's conviction, the defendant in that case, his conviction of endangering the welfare of a child under count 13 of the indictment must be reversed and a new trial granted on that count because the court erred in its supplemental instruction to the jury in response to the question whether that term knowingly can be interpreted as should have known. So are you guilty if you actually knew you were doing something wrong? Or are you guilty if you merely should have known that the thing was going on and you failed to actually realize and obtain the knowledge that you should have realized about the thing you were doing and what it could mean or would mean? Well, the court there in 1995 instructed the jury to evaluate the defendant's conduct from the standpoint of a reasonable person. However, and perhaps very astutely, the appellate department here realizes that because the degree of culpability required by the statute is actual knowledge and not knowledge you're supposed to have, nope, new trial. That conviction does not stand. Very good. What's important to note there is that this particular appellate division set a precedent for that relative level of that mid-level court within the New York system. On the face of it, it seems they're correct. The statute is the contains the terms of the contract of the covenant that we, the members of society, agree to. You can't read into the law things that we, the people, never meant to put into the law as our agreement. We put for actual knowledge to be prohibited. You don't get to stretch the bounds. People versus Williams was cited. In that particular case, a parent was getting into a physical fight with another parent, I believe, in front of the child. So they're assessing, is that exposure enough to knowingly create the risk of endangerment? Well, that court proceeded to state that the progeny of cases on this offense consistently requires that a person knowingly act in a manner likely to be injurious to the welfare of that child. While the likelihood of harm may be inferred from the circumstances surrounding the child in that particular situation, as here in People versus Williams, which is a domestic violence action brought against the defendant husband on behalf of the complaining witness wife, and they had 2 children. This court, back then, noted something very important, essential to a conviction of a violation of that particular statute, which is the attempted commission of a crime, is the mens rea, not only the actus reus, good old Latin terms. Mens rea is the guilty mind, actus reus being the wrongful act. There must be a union, a marriage of the wrongful act with the guilty state of mind, knowing that you're doing the wrong. That is when criminal wrongdoing may be charged and guilt may be found. This is what the law for millennia, since the time of Rome, has mandated. Actus non facit reum nisi mens sit rea. An act does not make the doer of it guilty unless the mind is guilty as well. Where they couldn't find the requisite intent to know that the actor in that situation, while he's beating his wife, is also going, yeah, look at how I'm endangering the welfare of my child right now. See how I'm doing it? I don't care, I'm doing it anyway. That is the level of inference you must have reasonably so. Reasonably meaning no one could fail to differ in holding that that is what he felt, knew, and intended at that point in time in order for that burden to be satisfied. In the instant case before them, the defendant was charged with attempting to endanger the welfare of the child. All attempt charges are applied pursuant to 110, which requires an intent to commit crime and conduct which tends to affect the commission of such crime. There's little difference between an attempt to endanger and the actual endangering, since in either event the statute does not require that an actual injury be effected upon the child, only that you've created the substantial risk of such injury, such that it is likely, is truly, genuinely likely. The question is whether the defendant, in that case, being fully aware of his conduct, was attempting to create a likelihood of injury to that child. The court finds that the testimony and evidence adduced at trial was insufficient to answer that question affirmatively beyond a reasonable doubt. So that's why can't find guilt. Not guilty. Lastly, in Affia, the defense cited for Affia a case of People versus Chase from 2000, which showed that upon the appeal, the judgment of the conviction for endangering the welfare of a child was unanimously reversed upon the law and the facts, meaning trial court felt one way, but for sure at the appellate division, we see it correctly, and we reverse it. They state that viewing the evidence in the light most favorable even to the prosecution, they determined that it could not be rationally found that the essential elements of endangering the welfare of a child were established beyond a reasonable doubt in that case. And that's good. That's what an appellate division and an appeals court is supposed to do. They go on to further examine and find that the penal law prohibits the knowing acting in a manner likely to be injurious to the welfare of a child, requiring that the defendant act knowingly and in a manner which is likely to be injurious. It's the same issue as before. They rule out and discard the should have known part. The culpability required by the statute is actual knowledge. That's when you're guilty. Smartly, they go on to state that A motorist who, while transporting a child, speeds, slides past a stop sign, passes a red light, fails to restrain the child in a seatbelt, or commits some other traffic infraction might readily be alleged to have knowingly acted in a manner likely to be injurious to the physical welfare of the child if the terms are too loosely construed. Indeed, with such a loose construction, many, if not most, motorists would, over the course of a lifetime, commit many misdemeanors, thereby meriting a criminal record. Are you going to take the person's child away, too? The evidence admitted in the case at bar showed that the defendant was driving while impaired as a result of his consumption of alcohol. He failed to lower his high beams in response to signals from a police car as he approached it on the roadway. And ultimately what they find here is that, absent the evidence, you can't hold a man as being guilty. So, back to Affia. Oh, that defense counsel did a pretty good job, actually. And nevertheless, in this case here, now, in 2006, the evidence is sufficient to establish attempted endangering the welfare of a child beyond a reasonable doubt. Boom, conviction is affirmed. What? We continue on. What's their line of reasoning? This court's decision seems to seriously contradict what was just shown earlier, which intuitively and sensibly made sense. Do courts at multiple levels commit errors like this? Well, we trust them with our safety, our lives, our dignity, our rights. They can't be messing things up consecutively or consistently. No. They're supposed to have logic, right? Well, let's track what happened. A person is guilty of endangering the welfare of a child when he or she knowingly acts in a manner likely to be injurious. Yep. The defendant there, Affia, within the school bus case, is charged with attempting to endanger the welfare of a child, which requires an intent to commit a crime and conduct which tends to affect the commission of such crime, as we covered earlier. The term knowingly is further defined as a person acts knowingly with respect to conduct or to a circumstance described by statute defining an offense when he or she is actually aware that the conduct is of such nature or that such circumstance does exist. Penal Law 2060-10 requires proof that a person knowingly acts. While the likelihood of harm may be inferred from the circumstances surrounding the child, perhaps the people are required to prove actual knowledge. Good that they admit this. So then what happened? Let's see. The defendant's argument relies on the theory that in order to prove knowledge, the people were required to show that the defendant committed an affirmative and intentional act directed at Isaiah, knowing that this act would result in harm. Oh boy, let's see. This is impressive. How are they going to twist this? You may think it's a little prejudicial of me to frame it that way. We're not even at the end of this. I've read this before, though. We'll see. We'll all come to the same conclusions together, but let's give them a fair hearing now. They proceed on. As the Court of Appeals has held, however, quote, criminal liability for endangering the welfare of a child is imposed when a defendant engages in conduct knowing it will present a likelihood of harm, with an awareness for the potential of the harm. Yeah, okay. The statute requires mere awareness that the defendant's conduct will likely result in harm. So the question is a woman in her position, we'll find out a little more of what happened in that case. Is she guilty? The people need not prove that the defendant committed an affirmative act directed at a child, only that there was Nevertheless, however, the actual awareness. So we see. In a cited case, People versus Hitchcock, the court there distinguished between two cases in which the defendant's omissions, their failure to protect their children from a weapon they possessed in their respective homes, caused injury to a child in their care. Now, that defendant Hitchcock, who had kept several handguns at home, none of them were under lock and key, and who also taught his 13-year-old son how to load a handgun, was subsequently charged with endangering the welfare of that kid after that son accidentally shot and injured a friend. The Court of Appeals affirmed in that case the conviction, holding that the defendant knowingly possessed and stored his guns in a manner that was likely to be injurious to the welfare of children. The Court of Appeals simultaneously affirmed the dismissal of the count of endangering the welfare of a child against Dueñas, who had taken considerable measures to conceal his gun from his child. So in one case, carelessly have a gun in your house where you know you should have done something different. Awareness of the risk of danger can be inferred. You know you have kids around, and And on the other hand, if you're actively doing something to prevent it, that shows that you can't infer knowledge or awareness to allow injury or a likelihood of injury. So, other courts have similarly upheld convictions where a defendant fails to provide adequate food, adequate clothing, and shelter to a child in his care. In cases where the defendant failed to adequately supervise a child left at home where the defendant was allegedly providing unlicensed child care services. In cases where people are driving dangerously and while intoxicated with the child in the car, or where a school bus driver simply left a child alone at the child's home without supervision. And probably there's more details and facts to those specific cases that show that it was a true risk of harm and not just, you leave a kid alone a little bit, that's not yet actual harm. But anyway, in this case, the undisputed evidence at trial established that Isaiah M. was one of at most 12 special needs children who had been in the defendant's care every school day morning on the minibus since the beginning of that school year. That's from September until that day in February. He boarded that minibus that morning with the defendant's help, and that he did not get off the minibus at his school. The defendant's sole responsibility, that Afia, in her capacity as school bus attendant, responsibility for which she's specially trained, was to supervise the children during the trip and to check the bus for sleeping children. The logical, if not inescapable, conclusion the court holds is that where a sleeping child escapes notice in a vehicle with a seating capacity of 12, is that no one looked to see if he was there. So, now, you and I, audience, we hold what? Okay. So we have enough evidence to understand at least that what? This woman, Victoria Afia, forgot to turn her head. Yeah. So if she forgot to turn her head such that it now ends up being the case that no one did look to see if he was there, is that criminal? The court here continues on. The court need not delve further into the defendant's mind to find evidence of the requisite intent. Her knowing failure to check the minibus for children. What? We intuitively can begin to feel something's not adding up here. No, the law, when perfectly applied, is perfect. But something just glitched here. Okay. The cases cited by the defendant's counsel are unavailing to his argument. No, they're not. We just reviewed these cases and took a look and found that everything that they said makes perfect sense. That's a little weird. In People v. Simmons, the Fourth Department held that the element of knowledge could not be proven where the defendant merely should have known. That's right, we agree. However, here, we're going to rewrite logic, my friends. This is not our conclusion in this case, where the people established that the defendant did know what? Did know that she's doing something likely injuring him, or did know that Isaiah was in her temporary care. And what? And that she knowingly failed to see him off the bus. My friends, let me tell you what knowingly failing to see someone off the bus means. It means you got off the bus and you're standing there and you're going, yeah, I didn't check to see if he was on there. Let me tell you something. If she even thinks that the accidental omission or the accidental overlooking can result in serious trouble to her job and life, she's not sitting there with any degree of actual knowledge in this case going, yeah, I'm totally possibly screwing some kid right now on this matter. We're watching logic break, my friends. Similarly, in People v. Williams, the defendant was accused of assaulting his wife. We took a look at that case in the presence of his children. There, the people could not prove the underlying assault. They reversed it, that's right. In People v. Chase, we also took a look at that. The court declined to find that a defendant who was driving while intoxicated had endangered the welfare of that child of his, where the record failed to show that the defendant was driving in a dangerous manner. That's right. Couldn't infer that the child was endangered in any substantial way. We are aware that the court in People v. Dalmage dismissed a complaint alleging circumstances similar to those in our case. Yeah. Let's see what they do now. However, that court did not have the guidance of the subsequent Court of Appeals decision in People v. Hitchcock, which we believe to be controlling. Let's think about that for a sec. Going back, that's that defendant Hitchcock who kept several handguns at home, none of them being under lock and key, who also taught his 13-year-old son how to load handguns and then leaves him in a situation where, you could possibly figure out that, a lot of bad potentialities could happen. He accidentally shot and injured the friend. Is that the same as accidentally forgetting to turn your head to check for the seat and the kid in the seat? Somehow we all intuitively know, no, that's not the same. What the hell is going on here? I continue on. Our case here is easily distinguished from People v. Dalmage by the testimony of Ms. Foy and Mr. Van Aken, who testified as to the training given to defendant. Indeed, Mr. Van Aken testified that he specifically advised defendant that her failure to awaken and remove a sleeping child, Ms. Affia, it would result in criminal liability. Wow. You see how the court here uses this as a way to establish that, see, they told her that this would be criminal if she ended up in a situation like this. That's why, because she ended up in a situation like this, we can infer criminality. No, my friends, I'm telling you that in fact, due to this reason that Mr. Van Aken is specifically advising that Miss Affey's failure to awaken and remove a sleeping child at any point in her life while on that job would result in criminal liability, that tells me that she has every motive, and reason to avoid doing such a thing on purpose, and it would only therefore ever happen because of the total freak, superly, highly regretted situation of an accident type. Where, by the way, you need both knowledge and, in an attempted case, actual intent to proceed with criminal liability. You must have the mens rea, the guilty mind. Where's her guilty mind? Something's not adding up here. While his views, of course, are not determinative of the law, that's right, they are sufficient to show that the defendant well knew, and not merely should have known, the consequences of her conduct in overlooking a sleeping child. Guys, I'm going to tell you something. I don't think she knew she was overlooking a sleeping child. Because if you're in her position and then the first moment you know that you overlooked a sleeping child or potentially sleeping child, or did I check? You go and do everything you can to protect yourself. Mind you, you need actual evidence in order to arrive at reasonable holdings. Remember, class, what's the definition of a reasonable holding? A holding in which reasonable minds could not differ as to whether or not a thing is so. Would reasonable minds all hold in common agreement that, oh yeah, she knew she was doing something messed up? The answer is no. And that's the secret shortcut to know that you have a not correct decision. Somebody messed up. Could it be everybody? We hold that a defendant who is entrusted with the temporary care of a 7-year-old child with special needs and who, being responsible for ensuring that the child gets off the bus when the bus arrives at school and being trained for that responsibility, nevertheless consciously fails to check the seats. How do we know she consciously fails to check the seats? So mind you, furthermore, this is all very tricky here. You guys remember the levels of culpability from last video. On the one hand, you have crimes that are prohibited on their face. If you do it, it doesn't matter what the intent is. If it's done, you're guilty. However, here, there must be some appropriate level of culpability. That is the mens rea. You must know you're doing wrong. Well, there's 4 levels. Number 1 is negligence. Number 2 is recklessness. Number 3 is knowledge. That is the threshold here. And number 4 is intent, an even higher threshold, which is the one that applies when you turn the charge from endangering the welfare of the child into the attempted endangering of the welfare of a child. So you're actually raising the difficulty of finding guilt as far as the finding for the mens rea is concerned. You people messed up. So, if you're consciously disregarding a risk, that's called recklessness. If you're accidentally failing to do something, that's called negligence. Even if she was reckless in her conduct, that's the highest level of degree of culpability I could consider. I'm half and half between whether it was negligence or whether she was aware of a risk but failed to act accordingly. That only establishes recklessness. That does not arise to the level of actual knowledge. So they're playing with words here. She nevertheless consciously failed to check the seats. Are you sure she did that? What evidence shows you that, to hold something like that as reasonably so, all things and all facts and all holdings in cases and in law and at the level of proceedings here must be reasonably held. How can you reasonably establish that she definitely did consciously fail to check the seats? What's the evidence? Was there some testimony there saying, yeah, I was next to her. She was joking at the end of the, bus ride about how, I just didn't check half the seats today. I'm playing Russian roulette. Maybe there's some kids there, I don't know. I didn't check. Ha ha ha. Anything short of that, just about, doesn't let the hall of witnesses / reasonable mind / jury, judge, everybody who's beholding the case here, we don't hold that you really did consciously fail to check the seats. At the threshold of reasonable holdings, we can only reasonably hold that she definitely at least forgot. Forgot is not the same as knowingly criminally acting. Yet people messed up. Furthermore, what's really sick is that the defendant lawyer actually correctly supplied the proper case law. They continue on. We therefore find, while a mistake may sometimes be just a mistake, that's right, as argued by the defendant, this court finds this is not one of those times, for sure. They say, we therefore find the defendant guilty of attempted endangering the welfare of a child. Footnote 1. A blank trip sheet was introduced into evidence as People's Exhibit number 1. Yeah. Right? Remember, she was supposed to fill in the trip sheet to indicate that everything was done correctly? A blank trip sheet was introduced. Means she didn't write it. That doesn't necessarily indicate that she purposely did anything. Since Isaiah testified as an unsworn witness, furthermore, corroboration was necessary both to show that a crime has been committed and that the defendant was linked to the crime. Well, and that's basically that. We'll finalize our answers next time. Thanks for watching.